Well, thank both of you gentlemen for being here, and I know we do have some differences on some issues, but appreciate the commitment to public service and the desire to do the right thing. Let me go on something, and I'm going to add a disclaimer up front because I want all my biases to be perfectly appropriate on the record. I'm a pretty fierce defender of tribal sovereignty. My own tribe's Chickasaw Nation. We're actually in litigation with the NLRB now, and so it's obviously an issue of great deal of personal concern, but it's also professional concern as well. As somebody that believes very strongly in tribal governance, and frankly, this administration has a very good record, by and large, in Native American affairs. It really does. I've worked with the president on everything from VAWA to increased funding for Native Americans. We're working together on an education initiative now. So this is an area that, frankly, in my view, it predates the administration, because the agency, in many years, accepted that tribal governments were governance. It had no jurisdiction there any more than it does over a state government or over the federal government or over a possession in the United States. We've pretty carefully drawn a line between this agency's responsibilities and public versus private employment. And again, before either of you were there, the decision was made at the agency that tribes would now come under their jurisdiction. If I recall right, it was early in the 2000s. So again, for over 65 years, tribal governments were outside. Then the agency unilaterally made the decision to take jurisdiction over some areas of their economic activity. Can you give me the intellectual justification for that decision by the NLRB?
Well, thank you, Mr. Chairman, and I appreciate your concern. And of course, I won't speak on the Chickasaw Nation case because that is before us and pending, and it would be inappropriate to do so. But our determinations relative to Indian tribes and our jurisprudence that followed that stems from San Manuel Indian Casino, which was affirmed by the D.C. Circuit in 2007. It follows the Supreme Court's case. It's Tuscarora and Coeur d'Alene in the Ninth Circuit, and it follows that framework. The NLRB generally, and I'm not going to get into the weeds on that because I'll probably confuse myself. The NLRB will decline jurisdiction if one of these exceptions apply. And that is if there is a treaty that specifically deals with the issue at hand, there will be no abrogation of that treaty. But in circumstances where a tribe is not fulfilling a traditional tribal or governmental function, such as engaging in a commercial enterprise like a gaming facility, a casino that is targeted to non-Native Americans, employing substantially non-Native Americans and not involved in tribal governmental functions, the NLRB has exacted jurisdiction. Where the circumstances are tribal government related, we have and will continue not to establish jurisdiction, so there's a balancing test that we utilize.
Well, a couple of points in response and then another question. I'm sure we'll revisit this several times in the course of the hearing. And without getting specifically in the case, the San Clementes, that's a tribally operate corporation, chartered corporation. There's a big difference with the Chickasaws who operated directly through their Department of Commerce, so they would regard it as a governmental function. And since the income is what funds their government, because these are governments that we don't allow to tax, we don't give them the full governmental authority, they would argue, and most tribes would. And by the way, just for the record, you mentioned the case you prevailed. If I recall, the Chickasaws actually won the opening round of this case in federal court in Oklahoma City. It now goes to you, and then my guess is this is going to go through the court system because most tribes feel very strongly about this. But again, we see a big distinction between entities that are operated by our government and that fund the activities of those government that evidently you don't see. Let me ask you this, and again, I'm running out of my time, so I'll come back to this. But, and this may predate you, so if you need to take this for the record, that's fine. I'm very curious about what sort of consultative process went on with tribes when this decision was made, because again, for many decades, the NLRB did not assume jurisdiction here, did not see that it had it. So can you sort of familiarize with me with whatever process it was as you made your decision to expand your jurisdiction into the area?
Well, if I could just address that briefly.
Certainly.
Because the chairman is the chairman of the board that sits as sort of an appellate adjudicative body of unfair labor practice cases. And so the record that's before them is a formal record that's established through an administrative law judge's hearing, and then there are briefs filed. And any kind of ex parte communications outside the scope of that would be problematic. On the other hand, my office constitutes the sort of investigative and prosecutorial office, and we engage in fairly extensive discussions with the parties before proceeding. And so I can't speak to the time at which the San Manuel case was initiated. As you mentioned, it was before our time. And I would note that your point, which is that there are cases in the circuit that it encompasses Oklahoma, which includes the 10th Circuit. The 10th Circuit law may end up being different than from the D.C. Circuit, and this may end up in the Supreme Court. But returning to your question, we have a consultative process, and as an example, there was recently an issue with the Little River band in Michigan where there was an unfair labor practice case. It wasn't a representation election. And it took us some time because of the weather in Michigan in the winter, and we were going to have an in-person consultation with the tribal council, and we set it up 2 or 3 times, and ultimately we ended up having a video conference for an extended period of time where they advised me and the people in my office of the tribal procedure for processing cases that they contended was similar to ours and that we ought to defer to. And we had an extended back and forth. Now, ultimately, we didn't agree with them, but we did engage in a full consultative process, and I certainly would commit that that's the kind of discourse and respect for the tribal government that we'd want to.
Again, I'll make this quickly because I've abused my time, and the gentlelady's time is next, and she's been very kind. And I'll come back to this, but the thing I'm trying to get at is number one, I'm not questioning your process or your effort to arrive at a fair decision. And again, this predates your time, so this might be a discussion for another time, but I am very interested in how and when the decision was made, again, before either of you were in your current positions, that the NLRB decided it had jurisdiction in an area which for decades it had never asserted jurisdiction in. So that's just a personal, where did the idea come from? Why was the decision made? Because it does cause a great deal of consternation among a lot of Indian tribes. They see themselves as subjected to a jurisdiction that they never visualize they would be, and indeed for the majority of the history of the agency chose not to exercise. So any information you can give me on how that decision was arrived at these many years ago would be gratefully received. And again, I thank the gentlelady for indulging me, and she's recognized for whatever question she cares to put to our witnesses. Thank you, gentlelady. Let me go back to my favorite subject now. So, take you back to the tribal sovereignty issue. And I want to pose a hypothetical, probably to you, Mr. Chairman, but either of you are more than welcome to answer it, because I think both of you would be an interesting perspective. As I look at this thing, and I understand that the agency has tried to make a distinction between it called governmental functions and commercial activities where tribes are concerned. And it strikes me when I look at state government, some states run the liquor industry themselves. They get a lot of revenue off of it. Some don't. They leave it in private hands but regulate it. I think of both state and national workforces at things like parks where there's lots of recreational activity. And it's you could argue whether it's directly a governmental function or not. So in cases like that, I would assume you don't presume you would have the ability to regulate the federal government in areas where it's operating private concessions, basically, as revenue streams, or the state governance where they're engaged in what are commercial activities but draw revenue out, or do you? I mean, I'm trying to understand the distinction between tribes that do that and other governmental units that engage in the same activity, and exactly where your authority, in your view, would extend.
Well, if I understand you correctly, Mr. Chairman, we would not get involved in state regulations unless those state regulations have gone into areas that are within our jurisdiction.
Are there, and I don't mean to interrupt, please, can you give me some examples of where that would be? I mean, where you have felt the need to do that? Please.
Just as an example, I think the distinction that's drawn is whether or not, if I'm following your question correctly, is whether or not the function is performed by a state government or a federal government employee, or it's a function that is performed by a contractor or some other entity. And the line is pretty clear in terms of the jurisdiction of the statute, that both state employees and federal employees are not covered by the Act. There has been, over time, a varying standard that's applied to the contractors, although it's been pretty much the same standard for a while. And basically, without getting into the nuts and bolts of how the standard gets applied, if the work's done by the contractor, the board will assert jurisdiction over the contractor, not over the state employee or state employees.
I understand that distinction. How would that apply then in a case where, take a tribal entity, again, the person performing work is a direct employee of the tribe, of a governmental unit. They're not a contractor, they're not independent, they are working directly for the tribe. Their paycheck is drawn there, their supervision is directly in line with governmental activities or with the, so that's to me where I'm having a hard time seeing where you can do it to one but not to the others.
And part of the reason is because there is not an explicit statutory exclusion for tribal governments in the statute.
It just says governmental units. There are the only ones I mean, I don't know, is there in the statute, and please correct me because I could very well be wrong here, for the District of Columbia or for territorial possessions, again, places you recognize as governmental units, and where, as I understand it, you don't exercise authority?
You're correct that there are other types of governmental units that are specified where they're not excluded. There is not the reason for the assertion in the context of the tribes is there's not a specific statutory exclusion with respect.
Well, but what I'm asking is, in all these cases that you choose not to, that has to be listed. I mean, all these entities. I mean, do we list America Samoa or possessions of the United? We may well. I'm not familiar.
The precedent on the board taking jurisdiction of employer is that the definition of employer is supposed to be interpreted broadly because of the remedial purpose of the statute. So absent a specific statutory inclusion, the board's tendency is to assert jurisdiction. There are circumstances in which the Supreme Court, for example, in the context of religious institutions, for example, has said the fact that they may be private sector employers, there are circumstances under which the board is well advised not to take jurisdiction because of the potential First Amendment implications. And the board relatively recently just decided a case in this area, kind of drawing the line where it will and won't assert jurisdiction in those instances.
We'll come back to this again, but let me just end with this, and I'll certainly give you the opportunity to reply. But I mean, this is a real friction point, because if you looked at the history of the relationship between tribes and the federal government, there's been case after case, and this is not directed at you, of overreach by federal authorities into the legitimate jurisdiction that had been recognized either in statute or by precedent. And I think that's what we have. This is my personal opinion in this particular case. I think it's going to be a point of great friction. With that, and again, if you care to say something, that's fine, or I'll come back in another round because I'm not quite done with this yet. But if I can, I want to go to one issue quickly and then yield back to my friend for whatever final question she might have, and we'll draw to a close. But this is actually more to give you an opportunity to address something where I think you've probably already taken appropriate managerial action. But in January 2014, there was an IG report that found the agency's Performance Management Awards program lacked internal controls to detect and prevent waste and abuse. The IG report stated that the program lacked certain records, documented policies, and awards were misappropriated by staff. It actually used pretty strong language, gross mismanagement. And it's my understanding they made 5 recommendations to you, that the agency agreed with all 5 of those, and hopefully you've had the opportunity to implement them. So I just wanted to sort of see where you were in that process.
Yeah, we actually, I had a monthly meeting with the IG yesterday, and we looked at where we are in implementing all of those things, and we are either have them implemented or are in process. We took that report very seriously and want to do what we can as expeditiously as possible to address his recommendations.
Similarly, I meet with the IG on a monthly basis as well, and we pointedly inquired about those situations, and we have taken internal steps to remedy all of those things. Our fiscal controls are much tighter. We have a CFO that is actively responsible for tightening those situations up. The circumstances involved in many of those reports involved employees that are no longer with this agency.
Well, I appreciate you gentlemen following up on that, and if you would, just keep us informed and let us know when you've reached the point where you're satisfied you've got the internal controls in place. Does the gentlelady have any additional questions?
No more questions, Mr. Chairman.
Okay, let me just end with this. First of all, I want to tell you, if I'm ever in a labor dispute, I'm going to hire one or the other of you, because I think you're clearly superb litigators, and you've been excellent witnesses. Obviously, some members of our committee, mostly on our side, well, probably exclusively on our side, have some concerns. And I think the ranking member made a good point in her opening comment when she said a lot of the concerns are not on the day-to-day management with the agency. Quite the opposite. You've lived within your budget constraints. It doesn't mean you'll get what you ask, because we're going to have a tight budget year around here. But these are not unreasonable kinds of requests that you've put in front of us in terms of your own budget. And I appreciate the speed with which you followed up on the IG's report and the effort to do the right things there. So there probably is a philosophic difference, in some of the areas where we see you pushing to expand. You would argue, I assume, that you're responding to the labor market or doing what's in your inherent abilities, and we'll just have those disagreements in areas like franchisees and some of the, and particularly tribal governance. We just have a very profound difference of opinion there, which I suspect will be settled in the courts at one point along the way. But again, I want to thank you for what you do, because the right to organize and the right, and Ms. Lee made this point very well, of non-union workers to still be afforded the protections they're entitled to are important. And the fact that you're pushing to look after people sometimes that don't have the ability to organize and look after themselves is not missed by this committee, and is appreciated. Where we differ, we'll make those points ever. But that doesn't lead me to question your professionalism or the dedication of the people in your agency to try and make sure that American workers have the rights to which they're legally entitled and the protections to which they're legally entitled. And I appreciate the fact you both devoted your entire careers, or much of your careers, to doing exactly that, both in the private sector and now here in the public sector. So just thank you very much for your service. Thank you for taking the time to come before the committee. I know we had some questions where we disagree, but I thought you handled them extremely professionally, and appreciate the attitude with which you approached them.
Thank you very
So
much.
thank
Mr.
you. With
Chairman.
that, our hearing's adjourned.